Throughout the day as well here on CourtTV. Let's talk about yesterday with trial attorney Bruce Rosenberg in San Antonio, Texas, and forensic psychologist John Delatorre. He is in San Antonio. Bruce is in New York. Bruce, good morning. John, good morning. Bruce, the cell phone video, how much of a game changer was that to place the defendant at the scene just minutes before the murders and totally contradict the story that he says he's up taking a nap? He's just resting his eyes up at the main house.
Yeah, good morning, Ted. It is very impactful. The bottom line here is that the testimony by the two witnesses is that they believe or they've identified the defendant as having been on that video by voice. We have yet to see, and the defense focused on the fact of the relationship. Is it 100% accurate that the identity or the identification of the defendant by the witnesses because of that video is 100%? I'm not so sure. There could be speculation or questioning brought into it as far as are they sure, and how good is an eyewitness or a witness that can identify solely through a voice over a recording. We'll see how strong that evidence is in the long run.
John, what's your take in terms of what juries absorb? This is the type of thing that everybody understands pretty clearly. You hear the video, and then you get the best friends of Paul, two of them saying, "Oh yeah, definitely Alex."
Yeah, I think we juxtaposed it with the other video that we've heard, the audio recording of the they sort of, recording where it's that kind of is left up to interpretation, whether you hear the word I versus the word they. But in here, you can clearly hear that there are multiple voices on this recording. And so I think the jury's left with, okay, well, maybe this other video, it can be interpreted in multiple ways, but there's someone else in that, right? I hear someone else. And because of Alex Murdaugh's unique way of speaking, right? The pitch of his voice and everything like that. I think the jury's left with, and two witnesses. I think the jury's left with this has to be him. I think this video is a little bit more impactful than the other video that we heard that still had interpretation left to it.
Yeah, he's got a bit of a high pitch going on there. The Snapchat video. Let's watch it and then talk about its significance. So you could look at this in different ways. You've got father and son hanging out. The boys making fun of the tree that they're trying to get up, and they're having trouble with it. The state is going to say, hey, look, he's wearing this blue shirt. He did change his clothes. But this is a few hours before the murders, and frankly, that blue shirt is he's full of sweat. I mean, it's not inconceivable that he's going to change out of that baby. Bruce, what do you think the significance of this video is, and maybe both sides use it?
I think for the defense, it's something that's usable because it shows that the father and son were having a good relationship, a good time, or involved with the tree. It was a funny moment, and the son figured he'd record it and send it out. I'm sure the prosecution can use it equally, but for the defense, I think that it shows that father and son are interacting in a normal manner in a usual relationship.
John, your thoughts on that? The other thing it kind of shows, I mean, Alex a little heavier at that time. He's not exactly Rambo. And the things that the time is that the window is getting smaller and smaller. And we'll talk about that in a little bit in terms of pulling all of this off. Your thoughts on that Snapchat video, significance, who does it help?
I don't know if it helps either one. I think both of them can use it absolutely equally. The problem is going to be the intervening time. And that's really sort of where the evidence needs to go moving forward, because I think the jury's going to want to know, sure, we can look at it and say that there's a loving relationship here. And the prosecution can say, look, this is clearly just evidence that he's been lying this entire time. But the problem is that people don't just snap. Right? When it comes to engaging in violent acts to include murder, especially murder against your own family, people don't snap. So there has to be some kind of intervening thing that compels him to engage in this act. And I don't know that we quite have heard evidence to support that, but we'll see. Maybe it is this financial crime, and we'll see how the judge rules on that.
Yeah. To that point, Bruce, quickly, do you think that the door was open when they asked the friend of Paul, hey, could you ever imagine Alec doing this to his family? Does that open the door for the state to say, oh, we do have a motive, and now, Judge, let us talk about it?
I don't lean that way. I hear what the impression is. However, I think that the counsel did point out, that defense counsel pointed out, that what they were inquiring in it is, did he know anything else? It was a general question. It wasn't targeted to the specifics of financial or other wrongdoing. I think the court, though, will look at evidence of prior conduct or outside influences to establish motive. I don't necessarily think that the defense opened the door, but I think the judge probably will allow some form of testimony about motive, which may very well include the financial basis that the prosecution wants to point out.
The state obviously won the day yesterday with these videos. However, the defense did land a blow, and that was during the cross-examination of the cell phone expert, when he explained that Maggie's phone, which of course was discarded about a mile outside from the crime scene in the woods, that phone wasn't moving at the same time as Alec's phone was moving. So how does Alex get rid of Maggie's phone without his phone moving when he was on supposedly his way to his mom's house? Let's listen to a bit of that testimony, and we'll talk about that.
Is there anything indicating that Maggie's phone and Alex's phone were moving together in those reports?
No, sir, it doesn't appear so.
Okay. If the same person had both phones on them and one of the phones was recording a significant number of steps, would you expect to see the same number of steps or something very similar on the other phone?
I would expect to see steps on both phones, yes, sir.
And you would expect to see those steps over about the same time period?
Yes, sir, give or take a minute or two.
So, John, how do you explain that? And this wasn't highlighted too much, but the defense is going to come back to this, that how does Alec get rid of that phone without his phone recording the same movements? Because that's what they've gone into these phones, and they're recording every little movement of the phone, and they don't match. Why not? Is that a problem?
I don't think that there's an adequate solution that the jury is going to be willing to hear. Because here's the problem: is that logically speaking, if there are two guns, then that usually means two shooters. So now probably there's some doubt coming in as to whether or not Alec Murdaugh is the sole perpetrator of this crime. And I think that it wasn't really nailed on all that well. And I think you're right, Ted, that they're going to come back to it. But I think the jury's kind of now wondering, did he actually do this all by himself? And if he didn't, who else might be involved, and how much more would they have been involved as opposed to Alec Murdaugh?
Yes, who would that be? Well, we do know that there is this other name that is out there, Eddie Smith, who was involved in the fake suicide scenario. And there he is. This is his. Look at this. So this is very odd. This is his inmate detail sheet. The charge. What does the charge say? Look closely. Hold for safekeeping. They're holding Eddie Smith for safekeeping. Is that to bring him in with that van and have him testify at the Colleton County Courthouse? We don't know. Is this the second person? Did he get rid of the phone? Can the state go that way? They didn't talk about it in the open. Something to think about. We're going to get a break here. Still with us, Bruce Rosenberg. He is a trial attorney in New York and in San Antonio, Texas. Forensic psychologist John Delatorre. And forgive me, gentlemen, if I cut you off. It means that Judge Newman has taken the bench. We're waiting for that to take place. Everybody has gathered in the courtroom just waiting for him on the bench. John, what'd you take from Judge Newman didn't want to hear from Harpoothian? It cut him off. You've done this before. Do you read anything into that?
Yeah, maybe a little bit. I think he was looking for something else. I think the judge was looking for a reason to not include this other than what he's already heard previously. So I wouldn't be surprised if some of this information actually ends up coming in.
Yesterday, Bruce, the prosecution brought up a couple of friends of the family, and then on cross-examination, the question was asked, do you think there's any way that Alec would be... any scenario you can think of that Alec would kill Maggie and Paul, and the response was no from a family friend, a friend of Paul's. And the prosecution jumps up after court is over and says, aha, they've just opened the door. Now we get to bring in the financial motive theory to this jury because they brought it up. They brought up what could be a motive. Well, doesn't the state have an answer to that question, and shouldn't jurors hear it, or do you think that door is still shut?
Ted, I think that the defense's point is very well taken. I don't think necessarily that the witness's testimony, quote, opened the door. I think that the question was related to, did that witness have any idea or any rationale as to why this might have happened? And I don't think necessarily that means that the witness was aware of any other circumstances, specifically the financial circumstances that the prosecution is referring to. So I'm not so sure it does open the door. I think the fact is, though, that financial motive or other motive that would cause the defendant to act, whether or not it's ludicrous, as defense counsel says or not, would be admissible potentially for a jury to consider. So I do tend to think that Mr. Arpunian was correct in saying that didn't specifically open the door, because it was related to general question about was there any reason. I don't see how that ties in directly to financial that the witness may not have had any idea about.
John, for jurors, how important is motive? The defense has presented this fairly successfully so far that this was a happy family, that this wasn't a case of crazy dad and no one gets along, and this was just boiling and simmering for years. They showed video yesterday of the family, a birthday celebration over the Memorial Day weekend prior to the June 7th murders of last week. Let's watch that and tell me, is this a happy family, or is this a stewing, soon-to-be double murderer?
Birthday to you. Happy birthday to you. All right. Happy birthday to you.
Thank y'all so much.
Hey.
Thank you, baby.
John, how far does that go with the jury, and how important is it for them to be presented with a reason why this guy would do such a horrible thing?
On its surface, it absolutely looks like a loving family. But that's the thing, is that on its surface, and no one really knows what's brewing underneath. While you never have to prove motive, I think in cases like this, where the crimes are so intricate and nuanced, when the relationships are so close, mother and son as the victims, I do think you need a motive, because the jury needs to hear a story that makes sense in their head. And without the motive, there's no story there.
All right, will the prosecution get to deliver that motive? Let's do this. Let's get a break in. They still haven't started yet. When we come back, we'll take you live into the courtroom. Stay with us. There's the seal of the great state of South Carolina.